This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about the common law and how a statute can eliminate a common law remedy, and why in the state of Mississippi there is no right to rescind a workers' compensation policy even if there is a material misrepresentation of fact or even fraud, because the workers' compensation statute in Mississippi silently abrogates the right to rescission by not mentioning it. The Supreme Court of Mississippi answered in the negative the inquiry from the United States Court of Appeal for the Fifth Circuit that certified the following question, quote, "Does the Mississippi Workers' Compensation Act, the MWCA, allow an insurer to void ab initio from its inception a workers' compensation policy based on a material misrepresentation?" Close quote. The decision from the Mississippi Supreme Court came in a case called American Compensation Insurance Company versus Hector Ruiz et al., a June 27, 2024 decision of that court. The MWCA is silent with regard to the equitable remedy of rescission, as are most statutes that have to deal with contracts, and that have no reason for a statute to deal with equitable remedies, only legal remedies. The statutory contractor, who will be on the hook if the subcontractor's insurer is permitted to void the policy, argued that because the MWCA does not provide for rescission, only cancellation and non-renewal, then rescission is not an available remedy. The insurer, who will be on the hook for millions of dollars if not permitted to void the policy, argued that because the legislature opted not to address the equitable remedy of rescission in the MWCA, it reasonably argued that the common law remedy of voiding the policy ab initio was available to it. The Mississippi Supreme Court noted, however, that a workers' compensation policy is different from other insurance policies. Not only is it governed exclusively by statute, but also it exists to pay benefits to the injured worker, not to the employer insured. Because the MWCA makes no provision for an insurer to void a workers' compensation policy based on a material misrepresentation, and because the MWCA exists to ensure injured workers are compensated, the Supreme Court concluded that the MWCA does not allow insurers to void ab initio a workers' compensation policy based on an employer's material misrepresentation, even though the benefits available to the injured worker are still available, and his employer must still pay if he had no insurance. Regardless, the employer, Hector Ruiz, doing business as Los Primos Construction, was performing work as a subcontractor for contractor Jesco Incorporated when his employee Raul Aparicio fell more than 15 feet and severely injured himself. Ruiz had a workers' compensation insurance policy with the American Compensation Insurance Company, ACIC, who initiated a declaratory action in federal court seeking to retroactively void the policy. No, they were seeking to rescind the policy from its inception, but the court said, and Mississippi read it as retroactively voiding a policy. ACIC alleged that Ruiz materially misrepresented in his application that his company did not perform work more than 15 feet above ground. ACIC asserted that had Ruiz been truthful, ACIC would not have issued the policy. It argued that since the statute did not change the common law right to rescind a contract, it was entitled to rescind. Well, the Supreme Court disagreed. The Mississippi Workers' Compensation Act represents a wide departure from the common law, according to the Supreme Court, by providing compensation to employees accidentally injured during the course and scope of their employment, regardless of fault. This right to recovery comes at the exchange or abrogation of the common law right to recovery from a potentially negligent employer, a right that existed before the issuance of the workers' compensation law. The Supreme Court of Mississippi concluded that rescission is inconsistent with the purposes of the statute for workers' compensation because rescission acts as a retroactive remedy and renders a contract unenforceable from the outset. In the workers' compensation context, however, the Supreme Court found that allowing rescission is tantamount to allowing an insurer to retroactively cancel a policy rather than the common understanding that a rescinded policy never existed. The Supreme Court concluded that in Mississippi, voiding the policy ab initio is inconsistent with the purpose of the statute, which is to provide assurance to the Commission that eligible employees are protected under the Act. Finding that the MWCA precludes a common law rescission action, the Supreme Court does not hold that an insurer like ACIC has no remedy against an employer who allegedly makes a material misrepresentation. They can sue the employer for damages, apparently. The sole question to the Supreme Court from the Fifth Circuit was whether the MWCA permits the remedy of voiding a policy ab initio based on an employer's material misrepresentation. And to this question, the Supreme Court answered no, it does not. Now, it was not a unanimous decision of the Supreme Court. Justice Coleman dissented and noted that Mississippi has recognized and followed a robust common law of contracts since well before the state adopted its workers' compensation law in 1948. And there is nothing in the workers' compensation law generally and nothing specific in Section 71.377 specifically that abrogates the common law of contracts principle that a contract based on a material misrepresentation is void ab initio. Justice Coleman disagreed with the majority's holding and his answer to the Fifth Circuit's question because according to well-settled law, a clear statement of intent, not silence, is required to abrogate the effect of the common law. And the statute clearly abrogated the common law of tort by its inaction, but mentioned rescission not at all. In my opinion, Mississippi, like almost every state, applies the common law and its equitable remedies. One of those remedies is called rescission, and that finds it is unfair to require a person to fulfill the terms of the contract that is obtained as a result of a misrepresentation or concealment of facts material to the acceptance of the contract and treats such contracts as if they never existed. That common law right can only, in my opinion, be eliminated by a direct and specific action of the legislature. By allowing rescission, the employer instead of the insurer must pay for the workers' compensation benefits owed to the injured employee, and allowing rescission might deprive that employee of the benefits, but does not support forcing the insurer to pay millions of dollars of benefits it would not have owed had the insured been truthful. I understand why the court did what it did, but believe Justice Coleman was more in line with the law, since the legislature could have included in the statute the elimination of the right to rescission, and it did not. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 4,800 blog postings. You can also subscribe to these videos at rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.